Welcome back to the second segment in this law session on the judiciary in English legal systems. Now, before the break, I flagged up for you an introduction in relation to the judges in England and Wales, and also we touched on, of course, the Lord Chancellor and looked at what the Constitutional Reform Act has done to date. What I want us to look at now is to consider judges and the different ranks of judges within the English legal system. Well, when you look at the judiciary in England and Wales, it is organized in a clear hierarchy of ranks with relatively low levels of specialization. So most judges will hear both civil and criminal cases at first instance and also at appeal. If you don't understand what I'm talking about, please go back to the law session on courts, where I speak about first instance and appellate courts. Now, throughout the system, there is a heavy reliance on the use of part-time judges, many of whom go on to be appointed to full-time posts. The point, of course, is that in England and Wales, you can still run your practice as a lawyer, so as a barrister, as a solicitor, and sit as a judge simultaneously. That's perfectly fine. All you need to do, of course, is if something comes before you where there's a conflict, that is declared. But the fact that you're still working does not take away from you being able to sit as a judge. Well, if we start looking at the courts and the judges who sit there, we've already in another law session look at the courts. Let's look at the judges within that system. Well, in the Supreme Court, we see that there was the bill creating the Supreme Court, introduced to Parliament in February 2004. We did see that there were some concerns. We had persons who were against this new Supreme Court. They saw this whole thing as being a change where they considered that where if you had a change to a new Supreme Court, it was something that would have been unnecessary and indeed could be harmful. They considered that the House of Lords was unique, it was in a prestigious setting, and given that it was the top court in the land, they felt that it was a kind of brand, and so it would be ruined, as it were. So they looked at also the cost of going through this change and considered that it wasn't worth it. Now, those in favor, of course, said that when you look at the idea of the functional separation of the judiciary at all levels from the legislature and the executive, then it was necessary, not least as a feature of a modern, liberal, democratic state governed by the rule of law. Fact of the matter is, you have the House of Lords sitting within the legislature. It does seem somewhat incestuous. And so those who are saying that it needed to be separated looked at it as being important and as a matter of constitutional principle that the functional separation should reflect the independence of the judiciary in all the circumstances. So, notwithstanding the detractors, of course, the Supreme Court came into being on October 2009, replacing, of course, the Appellate Committee of the House of Lords and assuming the devolution jurisdiction of the Judicial Committee of the Privy Council as well. Now, it is the highest court in the land. It is staffed by 12 independently appointed judges who are the justices of the Supreme Court. Now, Supreme Court judges are appointed under a procedure created by the Constitutional Reform Act 2005. Under the Act, it is specified that power of the appointment rests with a selection commission. Now, the Lord Chancellor notifies the Prime Minister of the Commission's recommendation. The final act of appointment is made by the Crown. When you look at the Court of Appeal, you have Lords and Lady Justices of Appeal. Now, judges in the Court of Appeal are usually appointed from the High Court. They hear both civil and criminal appeals. The Civil Division sits in panels of 2s or 3s, while the Criminal Division sits in 3s, usually made up of 1 Lord Justice with 2 High Court judges, or with 1 High Court judge and 1 Circuit judge. You then have your High Court judges. High Court judges, or puisne judges, spelled P-U-I-S-N-E, are usually appointed from the ranks of recorders or deputy High Court judges, or occasionally from the circuit bench. They are appointed to one of the 3 divisions of the High Court. And the 3 divisions, of course, are the Queen's Bench Division, the Family Division, and the Chancery Division. And they regularly travel around the country, and they hear the most important civil and criminal cases. Below that, of course, you have your Deputy High Court judges. Now, these judges are also senior practicing lawyers who sit as part-time High Court judges. They do not have security of tenure and are appointed when the workload of the court requires more temporary judges. Now, some will, of course, go on to be appointed to the full-time High Court bench. You then have your circuit judges. Circuit judges are usually appointed from among recorders or district judges, and circuit judges hear middle-ranking and more serious criminal cases in the Crown Court and civil cases in the County Court. You then get to your district judges. Your district judges are appointed from deputy district judges. Most district judges, of course, are former solicitors, some are barristers. They handle the bulk of less serious judicial work in the county court. Now, they carry out a wide range of different work, such as family work, family law cases, breaches of contract, negligence case, and so on. You also have district judges within the magistrates' courts. And if you remember in the last segment, I raised this to do with what were called stipendiary magistrates before. Now, district judges within the magistrates' courts are professional magistrates who are lawyers, unlike the majority of the over 30,000 magistrates who are lay people. Now, these district judges sit in the magistrates' courts, hearing mostly the more serious criminal cases, which is dealt with in the magistrates' courts. Now, they also hear some civil work, such as family law cases. We then have our recorders, and recorders are part-time judges, again practicing lawyers, barristers, and solicitors, who sit as judges for approximately 20 days of the year. Now, they hear both criminal and civil cases sitting in the Crown Court and County Court. Now, historically, a recorder was a certain magistrate or judge having criminal and civil jurisdiction in a city or borough. Now, a recorder was originally an appointed person with legal knowledge by the mayor to record the proceedings of their courts and the custom of the city. Now, such recordings were regarded as the highest evidence of fact. Well, since 1971, a system of part-time appointments has been in place in England and Wales, designed to give experience of judicial office to those who are not yet ready to take full-time appointment, and it is now the practice to require all full-time appointments to have had some part-time judicial experience. Now, the part-time appointees were initially designated as assistant recorders with a view to promoting them to full recorders. While the position of assistant recorder no longer exists, and all appointments are made now as recorders. Okay. How do we go about appointing persons to the judiciary? Well, the starting point, of course, is the Constitutional Reform Act of 2005. This has radically reformed the way in which judges are appointed, and the act, of course, took effect in 2006. Now, if we look at the old appointment procedure, now, before 2005, it is not something that you really would say that was the best practice when you look at a country like the UK. We saw that the Lord Chancellor played a central role in the judicial appointment. When you look at the Lords of Appeal in Ordinary and the Lord Justice of Appeal, they were appointed by the Queen on the advice of the Prime Minister, who in turn was advised by the Lord Chancellor. Now, High Court judges, circuit judges, and recorders were appointed by the Queen on the advice of the Lord Chancellor. And over the years, there had been considerable criticism of the way judges were appointed, not least because when you look at this whole idea of secret soundings, it seemed to be very nepotistic. Nepotism was rife, arguably, when you looked at the way the system was. And we see these radical reforms coming in under the 2005 Act. Now, in the past, only barristers could become senior judges. Well, that all changed in 1990 with the Courts and Legal Services Act, which widened the entry to the judiciary in order to reflect the changes in the rights of audience. Because it used to be that you had barristers who, of course, had an automatic right of audience, meaning they could advocate in court But as time went by and we see that solicitors could now have rights of audience in the higher courts, it certainly meant that this opened up the pool of the selection process in terms of determining, of course, who could be judges. Now, when you look at this idea of secret soundings, it really was about making informal inquiries from leading barristers and judges. That was the way they used to select the high court judges and the judges to the higher courts. The normal procedure then was to see, well, who might be good to be a judge. Now, when you look at the normal procedure for recruiting, it is a job which is placed as an advertisement in a newspaper for people to apply. Well, until recently, there were no advertisement for judicial office. You simply waited to be invited to the post. What we have seen, though, is that advertisements have more recently been the way forward, with junior and high court judges being advertised positions. Now, in the past, the final election process consisted of a traditional job interview. So for the appointment of most judges, this was replaced in 2003 with the attendance at an assessment center where you go for a whole day, and of course you would have to go through a panel. They would question you. You may very well have to do role play. And when you looked at it, the old system, even though, yes, these panels were great, there were, of course, criticisms, because when you look at it, you had, by and large, to rely on this interview process. Now, there have been criticisms of how judges had been selected in the past. And the main criticism, of course, was that it was dominated by politicians. And, of course, there's this idea of secrecy and arguably discrimination. Well, when you look at number one, the Lord Chancellor and the Prime Minister played central roles in the process, but they were politicians. And the question is, should that be the way? We get a short list being drawn up, and then, of course, it then goes to the Prime Minister to look at, and we have this selection being done. Now, from a second standpoint, when we look at the criticisms that have been leveled against the old system, we see a group called Charter 88. They're a sort of constitutional reform organization. They criticize the old selection process for being secretive and lacking in any kind of clearly defined selection criteria. The process was all about a small number of people who sort of kept it to their circle. It was seen by and large as being unfair, and there was then this sort of reliance, or dangerous reliance, on it being very much people from my own group. If I am the one saying, well, I think X would make a good judge, it's because I know X and I probably drink with X and dine with X and so on. Well, since 1999, the Law Society has also not been very happy about the whole thing, and they refused to participate in the secret soundings process because they said it had this element of the old boys network. And what we can see is that the necessity of an apparent legitimate system was needed. And so by 1997, we get a commission looking into the appointment of high court judges and seeing what exactly was necessary for there to be a change. Now, the study looked at the appointments of high court judges over a 10-year period between 1986 and 1996 and found that of 104 judges who were appointed, 70 of them, which was 67%, came from the same set of chambers, which had at least one ex-member among the judges likely to be consulted. So I am at a set of chambers, and it seemed that of all the chambers in England and Wales, the vast majority of 67% of judges were coming from one set of chambers. Now, that, of course, can't be right, because it certainly seems very odd. Now, there was a high percentage of appointments coming from the same handful of chambers. And when you look at about 28% of new judges, they came from chambers, which represented 1% of the total number of chambers in England and Wales. It was clear that there needed to be a change in the system. And frankly, when we see even criticism from Helena Kennedy QC, who said that she made a remark that the potential for cloning is overwhelming. We see the need for change. Secret soundings had to go. It needed to be a fairer, clearer, more transparent process. And this process, of course, we see has by and large taken hold. What I want to do now is take a brief break, and when I return, we will then look at how the changes have in fact been effected. We will look at how has any change been made with, or has any difference been made with the changes which have been implemented immediately after this short break.